Good afternoon, everyone, and welcome to Division 7 of the Court of Appeals. My name is Tony Navarro. To my right is the Honorable Alex Martinez, whom we are fortunate to have as a senior judge here today. As our earlier orders stated, Judge Jerry Jones cannot be here today, but he will participate in both cases on our 2:30 docket, and he will watch recordings of these proceedings. The two cases on our docket are U.S. Bank versus Mayotte and Booz versus Mesa County Valley School District. Our counsel for both cases present in the courtroom. Looks like I will direct my comments to all of you. The attorneys should have received written information discussing our oral argument procedures. If the attorneys at counsel table currently have any questions, you can ask them now. Seeing none, I'll remind you that each side has 15 minutes. Appellant's counsel may try to reserve some time for rebuttal, but I ask you to keep track of your own time with the clock on the lectern. I remind both counsel that these proceedings are being live streamed on our website, where they will also be archived. So please maintain confidentiality of any juveniles' names, sex assault victims, or any other information that you would like kept from the public in these proceedings. Also, attorneys, please identify yourself by name and attorney registration number when you get to the lectern. I ask everyone in the courtroom to turn off any cell phones and similar devices so that they will not disturb the attorneys in the oral argument. With that being said, I think we're ready to hear arguments in U.S. Bank versus Mayotte, number 17CA1763, and counsel may proceed when ready.
Good afternoon. May it please the court. John Campbell for the appellant, Mary Mayotte, bar number 50905. I'm a professor at the University of Denver Stern College of Law, and I am honored to have my client, Mary Mayotte, here with me. But I would suggest to the court that what we'll talk about today is certainly not academic. At issue in this case, as you well know, is whether or not my client will remain in her home until such time as a court hears the merits of her claim that she suffered a wrongful foreclosure, that she was not in default, and that she is the proper owner of her home, or whether she will be evicted from her home before determining whether or not she is the owner. Interestingly, the trial court in this case acknowledged this very dilemma. When I said, Judge, if you do it the way we're going right now, she could be evicted before there's a determination on the merits as to whether she is the owner or U.S. Bank is. He recognized that dilemma and then said, but sometimes it might have to work that way. Sometimes we convict someone who wasn't guilty and we only learn later that they were innocent. Your Honors, I would suggest that the law in Colorado does not require that result, and in fact, it prohibits it. The only basis for determining that my client should be evicted from her home in this forcible eviction and detainer was the court only cited two things in its order. Its order is found beginning at 1022 in the record. It said there was a Rule 120 hearing and there's a trustee's deed. It was the only two pieces of evidence cited by the court for eviction.
Well, there was other evidence that was introduced, was there not?
We introduced evidence, Your Honor.
Was there other evidence introduced by U.S. Bank?
Your Honor, the only evidence introduced by U.S. Bank were 6 exhibits. And they were, without having them all right in front of me, essentially the Rule 120 order, the notice of eviction, the notice of sale, the trustee's documents. They did not present, for example, any live witness testimony, any documents about the underlying transaction, about the foreclosure itself, about the payment history. None of those things were presented. So their position was, and it was unequivocal, they said, look, there was a Rule 120 that authorized sale, and we bought it. The case is over. She has to move out. And our position was that the law in Colorado for at least 100 years has said the opposite. It has said that whether it's a forcible eviction and detainer, referred to as you know, as an FED, or whether it is some other action, you have to determine the underlying merits of ownership and any other issues between the parties that relate to the foreclosure.
And you think the record is clear that the judge did not think he was determining ownership, as opposed to he thought he was determining ownership and because of the statute of frauds, he just thought some of the evidence you think is important wasn't admissible.
Yeah, I take your question, Your Honor. I think it's pretty clear that that's not what he was doing. First of all, in his order, which is only a few pages long, he doesn't mention the statute, the credit agreement statute of frauds prohibiting defenses. He doesn't talk about it at all. He doesn't engage with the evidence. He doesn't strike the evidence. Instead, what he says is, excuse me, I'm too many pages. What he says is that they have proven by a preponderance of evidence they're the owner. He relies upon the Rule 120 and the trustee's deed. And then he goes on to suggest that that this is not the appropriate court to unwind, as he says, unwind a Rule 120, and that he will not consider the malfeasance of Wells Fargo. And those are the reasons he gives not to discuss our evidence. And the problem here is that 3 cases in a row, I was somewhat surprised to see this, how clear this was. 3 cases in a row, the Colorado Supreme Court has said, an FED or not, you have to determine ownership, and you have to do that. If there's a full dispute among the parties, you got to dive in. And in the first case, Ritzy, the oldest of the cases, 53 Colorado 171, the Supreme Court went so far as to say it was proper to dismiss the unlawful detainer action because there was an action that would determine the merits of who the real owner is. Then in Lindsay, the court again said, we can't tell if this is an FED action or not, but we should dive in to determine ownership. And then finally, in Bigley, in 2001, the court said the same thing again. It said, regardless of the nature of the action, if ownership's at issue, you have to decide it. And we didn't do that.
Sorry to interrupt you, Mr.
No,
Campbell.
of course.
But how is your desire to litigate counterclaims and broad discovery consistent with the notion that an FED case is supposed to be an expedited proceeding?
Sure. The statute actually contemplates this. So in Bigley, Your Honor, the most recent of these FED cases, the court engages with that, I think only tangentially, but I think it was in the background. The statute itself says that U.S. Bank had the right to seek the posting of a bond if it believed that the delay, and Bigley actually talks about if there's delay litigating complex issues, U.S. Bank can say, well, we will be prejudiced by this delay, and we could lose money, and so they could have asked Ms. Mayotte to post a bond. They didn't. And so I think the court respectfully, and understandably, this doesn't happen that often, but the district court got a little confused. It thought that since this was supposed to be expedited, it meant that it couldn't be a full trial on the merits of ownership. And that's why you see it saying it will defer to a Rule 120. And I just want to emphasize, the Rule 120, as this court probably knows, says it's without prejudice to any party to challenge it in any court. And so for the court to say we will defer to a Rule 120 and I won't unwind a decision that is without prejudice was fundamental error. Yes, Your Honor.
Yeah, I'm sorry to interrupt, but your time is so limited, and there are a number of things that I think we would like you to at least talk about a little bit. One of them is that I would like to ask you is, and it relates to the question you were just asked, but what about the discovery piece of that? What is the basis for your claim that you're entitled to any discovery in an FED?
Well, so first of all, Your Honor, I would suggest again that those cases don't tell us an FED is unique. If in the nature of an FED, a defense is raised that invokes, for example, ownership, then we have a defense.
And I'm asking you for what you're relying on. Are you relying on Rule 26?
Rule 26, I think, is the start, Your Honor.
Isn't it inapplicable by its own terms?
To a proceeding in district court?
To an FED.
I don't think so, Your Honor, although I would certainly defer. My understanding of Rule 26, because we were in district court, is that it applies to claims and defenses, and that although this is an expedited proceeding, the Colorado Supreme Court's past 3 decisions, I will note all of those were robust. It was clear, although they don't mention discovery, it was clear that something had occurred. I mean, they were putting on evidence on both sides. And I don't know how else it would work, Your Honor, since there's a right to a defense in an FED. In this situation where Ms. Mayotte says, well, you foreclosed on me illegally and you told me not to make a payment. When I didn't make that payment to qualify for a modification, you instead said I was in default and began to take my home. And even then, when I made the payments you said I needed to, you still tried to take my home. All we asked for was proof that they had standing to foreclose so that the foreclosure wasn't void, and her own file. We didn't get either.
Did you also assert sort of third-party claims against Wells Fargo?
We did.
And what's your authority for doing that in an FED action?
Well, I guess I would say the 2. One is As I read the rules in the FED actions, I saw nothing that prohibited third-party claims. As I read the controlling cases, Lindsay and Ritzy, they involve, sort of, Bigley in particular, involves at least 3 parties, which I don't think all could have been original to the FED, because you always have just the owner. And when we filed those counterclaims, I'll just note that the trial court did not strike the claims as at all inappropriate procedurally. He struck them, it seems, one was the credit agreement statute of frauds, although that certainly couldn't have applied to abuse of process or to declaratory judgment count. Both of those which couldn't be barred by the credit agreement statute of frauds, and the court disposed of, I think, in a sentence. And in doing so, disposed of them, for example, the abuse of process claim, the district court said, well, she missed payments. Therefore, the claim is appropriate. Well, first of all, we didn't allege she missed payments. And second of all, of course, you can have an abuse of process claim in which it's colorable and legal, but it's brought for an improper purpose. And so I think they were appropriate. They certainly didn't raise that they were barred in an FED. The district court didn't find that they were, and I'm not aware of a rule that would prohibit them. I'm sorry that I don't have a pinpoint site. I'm not sure there is one, but I don't see anything that prohibits them, and I see a lot of history of them being litigated, including the Colorado Supreme Court allowing full litigation of claims. And I just return to that, Your Honor, Justice Martinez and Navarro, you both asked these sort of questions that get at how would this work? And I think the way it works is if you raise a defense, and that defense is not found to be frivolous, or at a minimum, you have a right to defend your home. Let's keep in mind, there's never been a determination that Marry Me Out was in default. The only determination was in a Rule 120 by a reasonable probability in a non-contested, non-adversarial proceeding without discovery. So when she said, wait, you're going to evict me from my home, but I'm the owner, that's a defense that has to be valid under all controlling law, including the law that says you must determine ownership. Then the question is, how does she do that? If the answer was, well, she can't have discovery and she can't have a real hearing, I think it would be illusory at best to let her try.
Mr. Campbell, I understand your argument to be in part that the trial court here could not rely at all on the 120 proceeding or the 120 order. And are you saying that that's as a general matter true, or particularly true here only because of your claim that the Rule 120 order was a product of fraud?
Yeah, thank you, Your Honor. I would say that, first of all, it's a general matter true, in the sense that the only party who relies upon a Rule 120 is the trustee who authorizes sale. And we have that base, for better or worse, we touch that base in Colorado where you can have a Rule 120. They say there's at least a probability of default, and it catches some bad foreclosures. But, I mean, the statutory language is that the granting of any such motion under a Rule 120, quote, shall be without prejudice to the right of any person aggrieved to seek injunctive or other relief in any court of competent jurisdiction. If we were to make a Rule 120, a decision to which another court defers, what we really had was we had a district court.
Isn't there a distinction between deferring or giving it sort of preclusive effect and just considering it?
Well, I think certainly it would be okay to consider that it happened. I mean, if there was an allegation that you didn't even have a right to have a sale, you could say, well, you had the Rule 120. Here, the district court said that I will not unwind a 120, and said, both in an order when we asked the court to sort of tell us the scope of the hearing and in the judgment, that it was not appropriate to review the merits of that. And so, Your Honor, what you have is everyone agrees that the Rule 120 is informal, non-adversarial, non-appealable, no discovery. And then you have a district court who says, well, I won't unwind that procedure that's not supposed to have preclusive effect. The result is a stamp of the procedure that then has preclusive effect. So if this court had instead said, I'm going to review.
That's what I was trying to get at. Is
Yeah.
You're actually arguing that the court gave it preclusive effect. You're not arguing that it was wrong for the court to consider it at all. In the few remaining minutes, can you touch base or talk a little bit about the statute of frauds, whether it's applicable and whether, if so, you are relying on the fact that you claim fraud was committed here?
Sure. I'll divide that into two parts quickly. I do want to reserve a bit of time. The first is that the abuse of process and the declaratory judgment counts were not thrown out on the credit agreement statute of frauds, nor could they be. Of course, the abuse of process claim did not turn on a representation, and the declaratory judgment is remedial and broad. I would just carve those out as, I don't know how those got thrown out, but I don't think there was any support unless you construe facts against us. The affirmative claims, the CPA claim and the negligence claim, both of those claims, first of all, we've made an argument, certainly a policy argument, but I think it's right, that the credit agreement statute of frauds can't be used to produce fraud. That's been true of all statutes of frauds for a long time. Second, I would say, we made an assertion that there was a promised modification that was not delivered after payment was made, the court construed that to mean it must have been an oral promise. As you can see from the evidence at trial, we produced a written agreement. We never got there because these were dismissed. And then finally, I would suggest, Your Honor, these are debt collectors. U.S. Bank is a debt collector. They didn't make this loan. They don't service this loan. They are the trustee for a trust that holds an asset-backed security. And this court and others have held, and we cite it in our brief, and I believe it's called Fisher is one and Schifrin is another, cases that said that if you don't qualify as a creditor, for example, if you're a mortgage broker, then the credit agreement statute of frauds does not apply. And for all those reasons, I'd ask the court to reverse the dismissal of the counterclaims as well. I'll reserve the rest of my time if that's all right.
That's fine.
Thank you, Your Honors.
Good afternoon, Your Honors, and may it please the court. Andrew Jacobs admitted pro hoc vice, therefore lacking a Colorado bar number, with Neil McConomy, Colorado bar number 46299. We are both from Snell and Wilmer. First of all, there was no appeal in this record as to Wells Fargo, which should suffice for affirmance of 2 of the 4 counterclaims that are at issue, those dealing with the CCPA and fraudulent misrepresentation. The fraudulent misrepresentation claim does not purport to attack U.S. Bank. U.S. Bank's name is not over that claim at paragraph 201, but even the CCPA claim is only about Wells Fargo. There are 29 mentions of Wells Fargo from paragraphs 174 to 201, and it just says U.S. Bank thought that was okay, basically, and approved what Wells Fargo did. So by not appealing as to Wells Fargo, we have only 2 claims remaining really that are alive, although there are many reasons to dismiss each of these claims, and the dismissal should be affirmed. As far as the statute of limitations, it's particularly troubling that in 2011, according to the plaintiff here, 2011 she knew that there was an assignment that she thought was improper. In 2011, she believed that, that she was going to be foreclosed upon, and that was pleaded in the August 2016 complaint of record. And so when you know in 2016 that you were getting foreclosed in 2001, you're really on notice. Even if you think the assignment stinks and U.S. Bank stinks, you're on notice that bad things, apparently, on your own judgment, are happening to you which are legally improper. And the statutes of limitation are all such that if you were aware in 2011 that you were the object of a foreclosure that you would then, in several courts, contend was wrongful, you should have, within 2 or 3 years, brought your claim. And for that reason, the remaining claims should be time-barred. And the Bennett correspondence, the correspondence with the Senator Bennett of Colorado, should not bootstrap that back into life, not to disparage the importance of talking to a public authority, but just as you can't, recreate on a continuing wrong theory something you were on notice of in 2011, you likewise, by writing to a public authority and expressing concern, cannot revive a claim that started running in 2011.
Mr. Jacobs, how or what effect, if any, does the filing of the federal claims have on your statute of limitations argument?
I don't think the filing of the federal claims gets them there because they were already expired before. They don't get reinvigorated, is my understanding of how the law functions on that. So they had already run through the entire 3-year period from 2011 before the filing of a federal claim, and therefore exhausted the whole period. I'm going to break out of what I had prepared to argue, to discuss, hopefully in conversation with you, some of the questions that you were raising to counsel, because I think there's something kind of fundamental here that is important to look at in terms of how the law treats the balance between merits and FED. And there was mentioned several times of Beagley versus Mack. I think it's unfair to the case below and to what the trial judge's work was here to say that the trial judge was ignoring evidence. What happened here was that there was a 2-step process that occurred below that is deeply consistent with Beagley versus Mack. Beagley doesn't teach that you always look at ownership and always have a trial about ownership. Beagley says, and counsel's entirely correct, at headnote 12, that generally speaking, ownership must be determined. But then it goes on to say, we're not going to let you break glass every time and, basically in a crowded theater and say ownership and stop the FED. So the way the law works is that the court can look at the merits of the claim, and that's what happened on the 30th of May, 2017. The counterclaims are sort of the elephant in the room in this analysis. The court looked at her counterclaims, and like he said, the court didn't look at them in some limited way. He's entirely right. So what happened was the court looked at a series of claims, all of which embodied her highest and best statement that she had been done wrong, that the assignment was somehow wrongful, and that there was not a power reposed in U.S. Bank to go ahead and continue because, of course, her theory would be that Wells Fargo was proceeding improperly in the course of dealing about the supposed modification that was all improper. and the court dismissed those. That's what Beagley says. So you get the look at the merits and the motion to dismiss. There wasn't a valid claim there for a variety of reasons. It was therefore appropriate to have a narrower consideration under Beagley in the FED proceeding, and that's what the statute calls for. It was appropriately limited, and notwithstanding that, the court nonetheless allowed the plaintiff to come in and to sort of demonstrate once again through her verbal testimony. She was heard in court as you would like to have happen in a system of justice. She was able, to raise her voice. Her counsel was able to introduce the evidence and was able to say, look, Wells Fargo was dealing with me and it, sent me this letter.
But Mr. Jacobs, I think the opponent's argument is that, yes, she was allowed to give evidence, but the trial court didn't really give any effect to it because the court was not going to entertain any arguments that would require it to upset the 120 order or that the notion that lawful title was obtained in the Rule 120 proceeding.
Yeah, and Judge Navarro, that's what I'm trying to, maybe I can say it a little bit better. What I'm saying is that they came into the case with the opportunity to contest ownership as an issue, and ownership was contested by virtue of the court's analytic consideration of the counterclaims and their correct disposition under Colorado law. Your cases do not entitle them to have that issue determined twice. The statute of frauds correctly resulted in the dismissal of some of the claims. The district judge did what he was supposed to do. He found the cases where successor assignees were entitled to the application in their favor of the statute of frauds. So it wasn't like the court never considered evidence. That's sort of how they're posing it, I agree. But what happened was her highest and best statement of claim was held up against the strictures of Colorado law, and the statute of frauds found it wanting in several particulars. There was a proper purpose in foreclosing or in the actions relating to abusive process because, it really stands abusive process on its head to say that a bank that's foreclosing is somehow abusing process. That's what the statute's for. It happens every day under statutes like that. And the abusive process claim is particularly, I would say, counterintuitive. Because you don't want to incentivize banks to foreclose people quicker because 2 years shows bad faith. You don't want to incentivize people not to enter into settlement negotiations because, we never got to a true settlement. Those aren't real indications of arguable bad faith. Those are indications of good faith, and they shouldn't be punished, and there was nothing here that stated a proper abusive process claim. So we think, Judge, that the proper thing was done under Beagley. We think there was more of a look at merits than you usually get in an FED because there was real analysis and real application of law to her real allegations. And nonetheless, she was let to have even more evidentiary showing at the hearing. But I think that's a red herring. I don't think the court needed to do that when the claims were all considered and properly dismissed. And that would be our position on the relationship of those things under Colorado law.
Do you think that Beagley and any of the other cases allows a party to challenge an FED, challenge in an FED the result of a prior 120 proceeding?
I think they were allowed to challenge the propriety of the 120, but going to the questions that your honors were having with counsel, I think it was not given all or nearly all weight. There's a deed of trust. They pleaded that we're an assignee. I think in paragraph 39 of their pleading at page 8 of the case file. So, if there's a deed of trust and we're an assignee, it seems facially proper. And so this court, as I understand it, sits in review with some deference to see whether there is some evidence to support the factual findings. So the 120 shouldn't be given complete and preclusive and absolute weight, which is sort of the easy position that they many times understandably state in their briefing. But that doesn't help you answer the question, I think, because the question is, like under Beagley, the proper balance between, can you give it some weight? Was there a look at the merits? I just explained why I think there was a look at the merits before that. And the 120 was only acknowledged as a preponderance of the evidence proceeding. It occurred. And nothing they did in the hearing really went against ownership. What they did again was they tried to represent the same narrative that was already honestly heard fairly and disposed of properly on May the 30th in the dispositive motion ruling. So they didn't say anything in there that tended to disprove the validity of the documents that were then introduced into evidence. And I do believe, going back to, I think, the first question in the prior colloquy, it wasn't just 2 items that the court relied upon. I believe it's at page 1023 or 1024 of the case file, which is the 4-page order. The court enumerates 6 different, all 6 were relied upon by the court, and the court further relied upon the 2 different documents that are issued in connection with the sale, the order authorizing and the order approving sale at the end of 2014 and the start of 2015. So it relied on all 8 of those. It relied on the fact of how the 120 came out. It relied upon the fact that the other side didn't come in and conclusively show, hey, I'm putting something here, kind of almost in a Celotex versus Cartwright way to roll that rock back up the hill, right? And show, no, those are all invalid. That really wasn't what their testimony at trial was directed to. And so even assuming they get that further bite at the apple, which I don't think is a matter of law and of Beagley they needed to get or entitled to get, I think they failed to push the rock back up against those proofs. And so even if it were de novo, I think we would win, but the standard of review is not de novo. So I think the question here, whether there is some evidence and substantial evidence to support the conclusion, I think the conclusion of the trial court as far as ownership is well supported.
Can someone assert non-ownership claims in an FED action?
Can they assert, non-ownership?
Yes.
That the other side doesn't own?
No, claims besides that one, besides the claims related to ownership.
That's interesting, Judge. I apologize for not having a quick answer to that, because my instant answer, which is not helpful, is that not all the claims here asserted, were properly disposed of. So I don't think they should be, Your Honor. I think that because when you look at Beagley, the real thing, and that's what my prior question, my long answer was directed toward, is trying to strike a sensible balance where ownership, as Beagley says at page 615, doesn't come in and destroy the FED. It's a statutorily quick procedure. Your cases here, I'll emphasize that. It's supposed to be quick. It's not supposed to be obstructed. So ownership, if it's really at issue, you kind of can get into that to the degree the court did here, but you really shouldn't be able to bring in, collateral matters, and it would disserve too much the efficiency goals of the statute, I think, Judge.
Can the case just proceed on two tracks?
Excuse me, Justice?
In terms of your reason that they couldn't be made in this action relates to how they would interfere with the expediencies. Could they just be heard on a second track? In other words, could the court deal with the issues concerning the FED and the ownership, and then postpone for later the issues concerning, whatever, Consumer Protection Act or whatever it goes?
I think, Justice, I think they can be. I think they can be. And though I don't have the privilege of sitting on the other side of this, if I were writing this, I still think we would come out on the winning side of it. But I would say that it would be worth reminding people that they have the opportunity to do that. But on the facts and posture presented here, Justice, we had the Consumer Act claim brought, and it would be time barred, though that wasn't emphasized, and statute of frauds barred. So I think that those claims could be brought, and I don't want to walk into being overly negative in terms of, the ability to later challenge what's in a 120. Now, they waited 22 months in terms of this proceeding. That doesn't stand in their favor. Statutes of limitation can run and can be important. The law doesn't want claims to be stale. But I think that a court would not be barred as an absolute from dealing with claims, perhaps doing the FED and setting those aside, Justice. I think that's exactly right. So as far as the FED proceeding goes, we've already reviewed what we were going to say about that. I don't think that the issue about the discovery presents really a valid challenge to Your Honors, in the sense that the discovery was requested, again, after the May 30 ruling. So the discovery is requested on July 13th, 2017, whereas the dispositive motion ruling is on May 30. And it's really the linchpin of their entire argument. It kind of goes unstated that this May 30 dispositive motion ruling somehow did not confer process on the lady, when it really did confer process. She had counsel at the 120, even though we don't rely on those as conclusive in res judicata, and we don't, and I'm not saying you should. And then there was counsel here, and it was counseled, and there was motion to dismiss briefing, and able counsel is briefing that, and that consumer fraud claim that you might not usually have time to adjudicate, it really was adjudicated here, which makes this an easier case than the messier ones that might otherwise result someday. So that really did occur. So at that point, when you come back and say, now I want discovery, that's the conflation that they're doing that they shouldn't be let to do. They're conflating this ability to get the peek at the merits, resolved here by the motion to dismiss, consistent with Beagley's structure of how it works. And then after that, you shouldn't be able to come in and request all kinds of discovery just for purposes of the FED once that merits peek, to the extent warranted, has been exhausted as it was here. That goes too far one way. That's not a sensible middle course between landlord and tenant. That's basically the exception that eats the rule and says, I'm always going to get to do unlimited discovery. And the exception shouldn't eat the rule here because, while efficiency isn't everything, it is an important part of the law here. And respectfully, we believe that Ms. Mayott's right to due process was served.
What governs that? I have a sense that what seems to be guiding this is like common sense of how do you make this expedient and still take a look at the ownership issue. Your conversation about the discovery seems to be sort of in the same vein. Is there authority that guides that? And if we were reviewing it, how should we review it?
I was just trying to say why I thought the law, the way it's constructed in Beagley, makes good policy sense. I apologize for lapsing a bit too much into that kind of talking. I think that as far as the discovery goes, you have a right to discovery in the civil matter, but the substantive claims were dismissed, and all you have left over is just the naked core of the FED at that point.
Let me ask the question differently. You really didn't owe me an apology, so I apologize to you if I asked the question in a way that seemed that way. Let me ask you instead simply the question, what governs discovery here? How should the court, in this kind of action, had the request been timely made, in your view it wasn't, how should the court decide what sort of discovery to allow?
I think that considerations of overbreadth that would inform a conventional civil claim would inform it here. And I think the idea that in a truncated procedure, even if their request was timely, that you're going to go through and stage some sort of 10-year examination of a loan file, that's not what an FED is, and that's not what an FED is for. And if I were the trial judge, I would have ruled that as overbroad and unreasonably, it would go too far. It isn't narrowly calculated to the purpose of what the discovery is for in this case, and it need not have been allowed. The documents necessary to prove ownership were there. They never tried to disprove ownership. They instead have an equitable theory that we're bad guys, an assignment is bad, and that somehow HAMP letters are contracts. That's their theory. They don't really have a theory at all that the ownership documents aren't ownership documents. If they had discovery directed toward that, which is the legally relevant question, they should have got that. But that wasn't what they wanted. They wanted a fishing expedition through 10 years of files, and they wanted to basically argue about equities and not argue about true ownership. So I think it was in that extent improper discovery-wise.
Thank you.
Thank you, Your Honors.
Thank you, Mr. Jacobs.
Your Honor, if I could, I want to pick up quickly on what I just heard, which stunned me. He said that if we had asked for discovery on ownership, we should have gotten it. Well, we only made 2 discovery requests. We didn't ask for 10 years of discovery. We asked for proof that U.S. Bank was the party with a legal right to foreclose, which would run to ownership. And we asked for my client's own file. So, for example, we might have shown that she was not in default, which would also mean she's still the owner because the foreclosure was void. Those are the only 2 discovery requests we made. The idea that they were untimely, I'm stunned by that one too, because I don't typically make discovery requests prior to dispositive motions to dismiss, which is what this was, because my experience with district courts is they often say, could we figure out what the case is before we do unnecessary discovery? So as soon as we knew what the case was, we asked for discovery on our defenses. There's also this argument, it's judicial alchemy, and it's brilliant, but it's not right, which is that somehow when the court considered our counterclaims, it also dismissed our defenses. But of course, they didn't move to dismiss our defenses. Our affirmative defenses are still in the case, and they included that the proper owner didn't foreclose and that the owner who was seeking to evict was not, in fact, the owner. All of this talk has avoided one fundamental truth. Ms. Mayotte has never been heard by any court on whether she is the legal owner of this home. And if she is evicted, and then we prove a year later that she is the legal owner, you won't be able to put Humpty Dumpty back together again. Someone else will have moved in, will be proven correct, and she'll have lost her home. This is why we asked the district court to stay the proceeding until the federal proceeding on the merits resolved. The district court refused, charged ahead, and it put expediency over substantive law. I would suggest to the court, respectfully, if I could just conclude, I have half a sentence. I would suggest that Beagley, Ritzy, and Lindsay all say that there is no balance, but instead, if ownership's at issue, it is fully litigated, and their protection is to seek a bond. And for those reasons, I'd ask the court to reverse.
Thank you, Mr. Campbell. Thank you to both counsel for your arguments. They will be helpful to the court. The case stands submitted, and a written opinion will issue in due course. Counsel in this case are excused, and we'll give counsel in the next case a few minutes to set up at counsel table. registration number when you get to the lectern, and also to remind everyone, to the extent there's anyone left, to turn off your cell phones if they are on, so they will not disturb the arguments. With that being said, we're ready to hear arguments in Booz versus Mesa County Valley School District number 17CA2261, and council may proceed when ready.
Good morning, Your Honor. May it please the court, Charles Kaiser, Colorado Supreme Court registration number 8557, here on behalf of Nancy Booz and Trish Hall. What I would submit to the court is what this case is really about in its essence is the difference between the democratic and political process as required by the General Assembly and the Open Meetings Law and the litigation process as created by a local government entity which is accountable to the public through the litigation process. And I'd submit to the court that the democratic process is a much more effective way to advocate to empower workers, as Ms. Booz and Ms. Hall are, than the litigation process, which is extremely narrow. The political process is much broader. I mean, specifically in this case, I don't see any meaningful dispute, although I stand to be corrected, that giving someone who's being terminated less than a day's notice that the elimination of their program is going to be considered by a school board without any substantial notice to the public. The only notice in this case was that the board was going to consider elimination of a program complies with the Open Meetings Law. What the district court said was the post-hearing process that was created by a school board policy mooted out whatever violation there might have been by the violation of OML. And that's why I'm saying we're talking about apples and oranges, the apple being the board meeting and the political process in which there would have been substantial opposition to the elimination of this program that serves students under the Individuals with Disabilities Act and the litigation process created by the local governmental entity, which was much more narrow.
Mr. Kaiser, I think in addition to perhaps the mootness finding, the trial court also found that your client didn't have standing because she lacked, or both of your clients lacked, an injury in fact because they were aware of the hearing, in fact, or the meeting, and they in fact attended it. So could you address that?
Yes, and that's the Pueblo City Schools case where we're talking about a completely different fact pattern where a sophisticated school district had plenty of advance notice that I think it was CHASA was going to take up. I think they were taking the football team down from 5A to 4A or vice versa. And in that case, the school district didn't present any evidence to the court, at least as cited in the decision, that they had anything that they couldn't have submitted to CHASA or didn't submit to CHASA in the appeal process for what CHASA wanted to do. Now, there's some language in Pueblo City Schools that said because the school district in that case, in Pueblo District 60 it was, had actual notice, that eliminated injury in fact. So Ms. Booz and Ms. Hall, in their amended complaint, were careful to submit to the district court, and it's in the record in this case, exactly what the injury in fact was. There was substantial opposition to the elimination of the job coach program. So if this court reads Pueblo City Schools to mean any actual notice at which a person affected by the public entity's action cures any violation of OML.
Mr. Kaiser, it seems to me that you're mixing two things. One is the question with your clients with regard to their standing is that they had actual notice. It would be helpful to me if you talked about that separately from, you seem to be talking about the rest of the public didn't have adequate notice, but I don't know how you can bring those claims on the part of the rest of the public.
Well,
that's
but that
what I
was
think you're talking about.
That was information, Justice Martinez, that the actual individuals, Ms. Booz and Ms. Hall, could have presented to the school board through an organizing process, and that they were able to do shortly after the shock of having their program eliminated wore off. We submitted to the district court the letters from a substantial number of
But the
people.
point is that all these substantial number of people are not parties to this action. and your clients had actual notice.
Right, albeit very short notice. Right, but the way, that's why, Justice Martinez, I'm talking about the difference between the democratic process and the litigation process.
Okay, so how do you expect us to work that in terms of the actual notice requirement? Or the actual notice that has been satisfied here? You think there's an exception because it was short? You think there's an exception because it's an unsophisticated party, unlike the school district? And how do we work with this notion that actual notice suffices? You think that that you should be able to bring the lack of actual notice to parties, to other people who aren't party to this? How would we write that?
And Justice Martinez, with all due respect, I somewhat disagree with the premise of your question, okay? Because what the OML says, it doesn't say actual notice, it says reasonable notice, okay? Which at a minimum is 24 hours, and 24 hours is the minimum, not the maximum. It's got to be reasonable.
So you think that we should distinguish Pueblo School District and say that actual notice is sufficient only if it is for some period, reasonable period beyond the less than 24 hours here?
Well, that's what the statute says, Justice Martinez. What I'm saying is injury in fact. I mean, the test itself makes it a fact question, in that not every time somebody gets actual notice, the court should conclude as a matter of law that there's no standing, there's no injury in fact. That's the plaintiff's position in this case. And so, especially
because it should, and I'm just trying to understand the test that you're suggesting, because it also needs to undergo a reasonableness test. Is that your point?
Well, it's a two-part test, Justice Martinez,
Okay.
is what I'm suggesting. Number one, was there reasonable notice as required by OML, which at a minimum is 24 hours? And then number two, if there's not reasonable notice, is there some injury to the individual, who didn't get the reasonable notice? And that's a fact question, I would suggest.
And what exactly is the injury here? I think you referred to inability to present information to the board. And where does that right come from? Is that in the open meetings law, that there's a right to present at a meeting?
Well, the open meetings law is silent, Judge Navarro, but that's a separate question. I mean, the board can argue that we wouldn't have listened to anything anybody said. We had our minds made up. But again, that's a fact question. I mean, the board, I don't think, can credibly claim it wouldn't have listened to, wouldn't have read the letters from people opposing the elimination of the program. I don't think the board can constitutionally only listen to one side when it makes a policy decision. We're talking about challenging a policy decision. We're not talking about whether, once that policy decision is made, whether there's substantial evidence to support it or whether it's arbitrary and capricious. We're talking about the policy decision in the first place, which is a political decision that's subject to the democratic process. So, you don't have to sit there like a potted plant at a school board meeting. School boards have public comment. People can send letters to the school board. People can get up and talk. So that's the injury in fact. And even, I'm sorry.
Just a quick follow-up. Did you allege in your complaint that the board meeting here had a public comment or a public response period?
Well, what I said in the complaint was, as I recall, that I put it conditionally, I think, in the amended complaint. If the board had given adequate notice and if it would have listened, then people could have submitted information that could have changed the policy decision before the steamroller started pushing through. And as I recall, the court has the complaint in the record, the amended complaint, that the board would have considered any written submissions. So I think, Justice Martinez, even under the plausible claim standard, that made it a question of fact that the court couldn't just determine as a matter of law. We don't have to anticipate when we file a complaint every possible defense that a party's going to raise or every collateral issue. So yes, I would suggest that the complaint adequately alleged an injury in fact and that it would have made a difference. Again, on a policy level as opposed to a litigation level. I mean, and that's the essence of what we're saying, that Pueblo City Schools, if it stands for the proposition that any actual notice eliminates standing for any person who may be affected by a violation of the open meetings law, that would be a matter of judicial legislation, and the court would be, not essentially, the court would be rewriting the open meetings law. That's a question for the General Assembly, and as the court knows, what the statute itself says is anybody affected can raise the rights of the public, the OML says, in a claim for violation of the OML, which indicates a legislative intent to grant broad standing. Now, I understand that the legislature can't require a court to render an advisory opinion and that standing has a constitutional basis. But in this case, given the legislative intent and given the broad language of the OML, we suggest that the lack of injury in fact, or the existence of injury in fact, isn't something that can be just resolved on the bare face of a complaint.
Mr. Kaiser, did you allege in the district court that Pueblo City Schools was wrong, although the district court had to follow it? And more importantly, are you alleging that in your argument on appeal, that we should disagree with Pueblo City Schools?
No. Judge Navarro, I've been to your trainings, okay, not yours in personal, but I've been to appellate judges' trainings, and what they say, what I've heard them to say, is that deciding the case isn't the hard part. It's writing the opinion in a way that serves as future precedent. That's why when a court considers a prior case, it also leads to look at the facts as well as the language in the case. Pueblo City Schools was clearly correctly decided. I'm not asking this court to overrule it, and I'm not asking this, and I didn't ask the district court to overrule it. What I'm saying is that Pueblo City Schools should be limited to its facts, and that otherwise, as this case illustrates, the court would just be creating a roadmap to get around the open meetings law. I mean, that's what I'm trying to say, Judge Navarro.
Thank
Okay,
you.
I'm not asking this court to overrule Pueblo City Schools. It was correctly decided. Not for me to tell this court that it made a bad decision, but I'm not saying it was a bad decision. I'm just saying it should be limited to its facts.
Thank you.
And you know, I mean, the other problem in this case is that the motion to dismiss was addressed to the original complaint, not the amended complaint. We're not asking the court just to send it back to start over. What we're asking this court to do is remand the case with guidelines on the issues that may arise on remand. And I've got 2 minutes and 50 seconds, so if I might, I'd like to reserve the rest unless the court has more questions.
You may.
Good afternoon, Your Honors. May it please the court, Andrew Teskey, registration number 36974 on behalf of the appellees, Mesa County Valley District Court. School District number 51, I'll call them the district, and the Board of Education for the district, which I'll call the board where it's necessary to make a distinction as we go forward. It's an honor to be here with you this afternoon. And I hope this is an opportunity to clarify, as some of your honors questions have already attempted to do, the issues in this case that require your attention as you resolve the appeal. In particular, this case really does not raise terribly complicated issues of fact or law. The facts and the law are relatively clear and have been for a long time. But this law is very important. As suggested by counsel previously, this really revolves around issues, bedrock issues really, about the relative rights of the judicial system, the judiciary, to review the decisions of other government bodies like the district in this case. And so the outcome and the way that your honors write this opinion is of significant importance. It's important to note at the outset that the appellants, Ms. Booz and Ms. Hall, are the only two people who were employed by the district as job coaches at the time that the job coach program was eliminated through a reduction in force. I may sometimes call that a RIF, R-I-F, reduction in force. That was approved on January 3rd, 2017. The program was eliminated because the district had made a determination as a matter of policy favoring economics, essentially, that the district should seek to obtain services in the cheapest way possible. And that was based on evidence presented from district representatives to the board regarding the duplication of services being provided by Ms. Booz and Ms. Hall as job coaches to those services available to the district through the Colorado Division of Vocational Rehabilitation SWAP program. As a result of that conclusion and the following process that went through, and I'll talk more about that later on if your honors would like, the court determined, the district determined as a quasi-judicial matter that the employment of the appellants here should be eliminated or should terminate March 7th, 2017. That was the date of the final determination. The appellants here seek to get their jobs back. That's what the underlying complaint seeks, both the original and the amended version. And in doing that, they make two different types of claims, both of which the trial court properly determined it did not have jurisdiction to hear, although for two different reasons. Really, the argument that we've just heard focused on one of the two of those. I may touch briefly on both of them if there's time to do that. The first of those claims is what the argument we've just heard focused on almost exclusively, and that is the open meetings law notice claim. As indicated by counsel, the open meetings law notice claim is essentially that the notification, the language used in the notice provided for the January 3rd, 2017 meeting of the board was not full as required by 24-6-402 sub 2C. And the OML, just to back up a second, is intended as a policy matter to give the public access to government activity, to allow the public to observe what the government is doing in an open meeting, so that, as counsel has pointed out, the democratic process can work from an elections perspective, so that we can select our leaders. Here, a division of this court, Pueblo City Schools, has already determined that citizens who have received actual notice and therefore been at an actual hearing, or meeting in this case, of a public body, have suffered no injury in fact as a matter of standing. And as your honors seem to have assumed from your questions, every plaintiff in the state must show standing. Injury in fact to a legally protected right. Notice is a right protected by the OML, there's no dispute about that. The issue here is whether these individual appellants have suffered any injury in fact. And the fact remains undisputed that they actually attended the meeting in question.
Mr. Teske, before we get to that part, do you agree or do you concede that the notice here did not comply with the statute?
Well, we don't concede that, Your Honor. We think it did. The test that was announced by the town of Marble v. Darien, which is somewhat peripheral to the briefing in this particular instance, is a flexible test regarding the objective awareness of an individual in the community regarding what the notice might have meant. And so the issue here, it just never got reached. And unfortunately, the point is irrelevant with respect to the appellants in this case. The appellants themselves must show standing as a matter of the Constitution, and they can't do that because they were actually at the meeting. Whatever notice it is they received was sufficient to draw their attention to the meeting, and they were physically there to observe all the proceedings that took place.
What if they didn't receive any notice, they just happened to show up at the meeting for other reasons? Would that qualify, or would that deprive them of standing?
I think it would. That may be a harsh result, but I think it would deprive them of standing. And in that sense, this is a sort of test of pragmatism. It doesn't make a lot of sense to suggest that an individual who showed up at a meeting and actually saw all of the process that took place there to later complain that they didn't have notice of what occurred. Again, as I mentioned, something drew them there. I suppose, taking your hypothetical, if they'd hypothetically wandered in off the street by mistake, they still saw everything there was to see at that meeting. That's the right, fundamentally, that the OML protects. And so in terms of showing injury in fact, I think they couldn't.
So your argument seems to be based on the notion that the only injury that they could possibly show would be being totally unaware of the meeting itself. Because if they have the actual notice, then they have no injury. I don't want to make Mr. Kaiser's argument for him, but it seems to me that part of what he might have been saying is that the injury here instead is one that the statute contemplates because it's part, as you indicated, of a democratic process. Mm-hmm. And the idea is that people could show up, they could protest, they could attempt to get other information, other people could be aware of it. And so I think that's the injury, if I understand his argument, that he is claiming. Why is that not an injury that would give him standing or give his client standing?
Certainly, Your Honor. And I think the answer is a simple one. That's simply not an injury that arises under the notice provisions of the Open Meetings Law. The notice provisions of the Open Meetings Law protect a very specific thing, which is a right to notification. And if you've showed up at a meeting, then you've received what notice you're entitled to. You have actual notice and are there to see everything that occurs at that meeting, which is the right the OML protects. The other rights that you've suggested, perhaps the right to protest or the right to participate in a meeting, are not rights guaranteed by the OML, but rights that arise under some other provision of law. And those provisions or those issues were never raised at the trial court below, and they're not raised here either. The claims made by the appellants in this case are exclusively limited to notice under the OML. So with respect to that specific issue, they wouldn't be showing injury, in fact, to that protected right.
What about the notion that the right that the OML gives is to reasonable notice? And they didn't, and if, assuming for the moment they didn't receive reasonable notice, isn't that an injury?
Well, in this instance, it's not. Even if the notice had been unreasonable, and again, that's not
Right.
a position that we're taking at this point, but assuming for purposes of argument that it had been, they still showed up and actually saw all of the government activities that took place at that meeting. So from their perspective, they can't be harmed by a lack of notice when they actually saw all that there was to see. There's nothing to be gained by requiring additional notice or another meeting. They actually, so with respect to these claimants, they actually saw everything there was to see. Going back to redo it, which would supposedly be the remedy, would give them nothing they don't already have.
Thank you.
As I mentioned, this is an issue that's already been addressed by the Pueblo City Schools case and correctly decided by a division of this court, echoed in the findings of the United States District Court for the District of Colorado in the Douglas versus Mountain Song School case, which is somewhat analogous to this one as well, a termination case, where the same result pertained. Functionally, as I mentioned, this question of justiciability and standing is really one of pragmatism, at this level at least. Having received notice and been to the meeting to see everything that the OML gives a right to see, there's simply no injury, and the trial court's determination in this regard should be affirmed. The second category of claims, which really wasn't discussed much in the earlier argument, are two claims, really, that were reclassified by the trial court as claims under Rule 106A4. Those two claims were a claim regarding due process under Article 2, Section 25 of the Colorado Constitution, a claim that itself has been found to be non-existent by the Colorado Supreme Court, and a claim for breach of unilateral contract. Those two claims both involved the same sort of constellation of operative facts, which challenged the district's action under its own employment policies in approving the RIF and then the subsequent proceedings that occurred afterwards. And in this instance, the court was again correct in finding that it lacked subject matter jurisdiction as a result of the time bar imposed by Rule 106B. As this court is undoubtedly familiar, the sole basis for a challenge to a lower government's quasi-judicial action is under Rule 106A4, and other determinations of this court and the Colorado Supreme Court have instructed the trial courts to reclassify any claims that are made before them as claims under Rule 106A4 when that's the basic thrust of the claim. And that was the case here. The RIF started in January of 2017 and concluded in March, as I mentioned, with the actual dismissal of the appellants. However, throughout that time, the court was satisfying the district was acting quasi-judicially in the way that that test has been framed by the Colorado Supreme Court in the Cherry Hills case. The Cherry Hills case essentially acknowledges that quasi-judicial action is being undertaken any time that a lower government body is acting in a way that bears some similarity to a court. And has a two-factor test for that. First, that the decision is likely to affect specific people, and the second, that the decision involves a pre-existing policy determination being applied to past or present facts presented to the government body. And that's exactly what happened here, as the trial court found. Beginning with the initial RIF determination in January of 2017, the district was aware, and the board was aware, that the only two people affected by this decision would be Ms. Booz and Ms. Hall, discrete individuals, satisfying the first prong of that Cherry Hills test. To the second part, the district then applied a pre-existing policy determination regarding efficiency in the delivery of its services, a budgetary consideration, to past and present facts that were presented to it, initially by the district staff at the meeting in January, and then through the appellants themselves, through a fully adversarial evidentiary hearing process that occurred in front of a hearing officer.
But counsel, I'm not quite sure I have a full handle on the plaintiff's arguments, but I thought part of what they were saying is they're challenging the policy determination, the quasi or the clearly legislative decision to eliminate the program. And it's that decision, which was not quasi-judicial but legislative, is what violated or led to the violation of the due process and contract rights. And why is that not a proper subject of this kind of action?
Well, functionally, because it has two problems. One, treating it that way does violence to the fact that this was an integrated process. It started in January 2017 and concluded in March, but the process throughout was to consider whether or not the employment of these two individuals should continue based on the evidence regarding the alleged duplication of services they provided to the district. So throughout the process, to segregate the first decision off from the rest, suggesting it was legislative while as the rest was not, is just not consistent with what actually occurred.
And is that dependent on the fact that there's only two people affected? Or what if it was 200? Would you have the same
Well,
argument?
functionally, yes, Your Honor. You could imagine a reduction in force determination, for example, if the district had decided to save 10% on its employment costs and had made a reduction in force based on that, and then asked for the superintendent to provide a plan for how to do that in a way that would affect a broader group of people, then certainly it's possible that that process would result in a different outcome than this one does. But in this instance, it was clear from the beginning who specifically was involved and to what degree. So as a result of the path that was actually followed and the circumstances actually occurring in this instance, this entire process was an integrated quasi-judicial determination. I would also mention, just as my time is expiring here, that it's unclear, certainly to the district, how challenging only the quasi-judicial determination, if that's indeed what the appellants are doing here, would be effective to get them the relief that they claimed below in the trial court. If they've been terminated, these are classified employees who are not protected by contract or by TECTA, the teacher disciplinary statute, or otherwise, and are only entitled to the process afforded them by the district's own policies, then challenging only the quasi-judicial action seems to get them know where they need to be.
You mean the quasi-legislative?
I'm sorry, yes, correct, the quasi-legislative decision only. Since the quasi-judicial decision would still stand and be unchallenged, it's unclear how they would get the remedy that they've sought. At any rate, Your Honor, for these reasons, we'd ask that the trial court's determinations be affirmed. Thank you very much.
Thank you.
Well,
Go ahead, Mr. Kaiser.
if observing the actions of the governmental entity were the only right, is the only right that's protected by OML, then there's no standing and no injury in fact if you get to watch the video of the board meeting after the fact. That's clearly means something more than that. It's access to the democratic process, number one. Number two, I mean, in Pueblo City Schools, the school district received actual notice well ahead of time, so there really wasn't any issue with reasonable notice because I mean, if CHASA had given, you know, the public notice ahead of time, 30 days ahead of time, as the district in Pueblo City Schools knew, that would have been reasonable notice. That's different than the 12-hour notice in this case. And so, and again, I'm not going to repeat myself or don't need to take the full 15 minutes. Pueblo City Schools, the plaintiff in that case didn't have any evidence that they could have presented something in the public session or the political or democratic process wasn't affected. When there's a request for reclassification of a school's football team, the party requesting the reclassification has ample opportunity to say why the governmental action should or shouldn't be taken. So unless the court has any other questions, I don't have anything else.
Thank you. Thank you to both counsel for your arguments. They will be helpful to the court. The case will stand submitted and written opinion will issue in due course. Counsel in this case are excused. That concludes our afternoon docket, and the court will be in recess, and the bailiff may so announce.